ignition interlocks, IIDs are required when your license has been suspended because of a court DUI conviction or a DMV administrative hearing suspension. And to get one of those, you need to be enrolled in a DUI school, have SR22 high-risk insurance on your person, which is different from your regular auto insurance, and have an ignition interlock installed, and you have to pay a reissue fee at the DMV. It's required typically at the end of a case if you are convicted of a DUI, if you do not win your administrative hearing. And so you don't need to get one right away. Well, after you get arrested, you can get it later. Sometimes, however, in cases with DUI accidents, injuries, and multiple offenses, or if someone's got kids in the car with a real high alcohol level or an accident, or they have a prior DUI, really bad driving, or, really high speeding. Just when we have multiple issues, not just you were barely over the limit and got arrested for a DUI. In these more complex cases, in some counties in the San Francisco Bay Area, a smart attorney may say, hey, you know what, let's get an ignition interlock device, an IID, put on your car now, because when we go into court, that will look good for the judge, because otherwise they might want you to wear, in some counties, an ankle bracelet, an alcohol monitoring ankle bracelet. I've had situations like that. I've watched a lot of other attorneys' clients have to put those on and wear those for months, sometimes longer, while their case is going on, where in those situations, if they maybe put an interlock device on early, the judge would have said, oh, this person's being proactive. They've done that. They're enrolled in DUI school. They're doing AA meetings. They're doing therapy. They're doing all these self-help things to show the court that they're serious about not reoffending, because that's what the court is worried about, is reoffenders. And so their catch-all is saying, we're just going to make sure you don't drink at all. And then we know that you're not going to be drinking and driving, because you're going to have an alcohol monitor where you go to jail if you violate this condition of release, versus just putting an IID on a car. You can drive any car if you want. It doesn't have an IID on it. If you have an IID on yours, the court's not protected in those situations. The public's not protected in the court's eyes. But the ankle bracelet is so much more a better way to, in their minds, to protect society. But the proactiveness of the interlock will convince a number of judges that, hey, this person's doing enough, and I'm okay with that. I don't need to make them put the bracelet on. The bracelets are not fun because you can't bathe in them, can't go in a pool, they itch. There's a lot of restrictions with them. There are, extreme situations when you might want one early, but in most cases, as I was saying earlier, at the end, and then plan out the timing with an experienced DUI lawyer who can help minimize the amount of time you need with that device.